Welcome to WRMN 1410 AM here another Friday afternoon with William Pelarenos on Life Experiences with William Pelarenos. And today I have a very special guest, Bob Mucci, also known as Robert Mucci, and he was a public defender with the Cook County Public Defender's Office for over 34 years before he retired. And I used to run into him when I was a policeman in cases. I used to run into him at the Skokie Courthouse. So I happened to see that he has a novel on Amazon. So I asked him to come and talk about it. Welcome to the show, Bob.
Thanks, Bill. Glad to be here.
Are our phone lines open today?
They sure are. 847-931-1410.
Are we on YouTube?
YouTube.com at WRMN Radio.
Our screens are down here.
We're getting some updates going, but we're still on the air.
Oh, so they can see me on YouTube?
Of course.
But I just can't see myself.
We'll get it updated. You should be good.
We should be good. As long as the listening public can hear us and the viewing public can see us on YouTube, that's fine. So our phone lines are open. What's the YouTube channel?
YouTube.com at WRMN Radio. Okay.
So with that being said, Bob, I ran into you when I was a policeman. I had many cases in Skokie, both traffic, DUIs, misdemeanors, and felonies. But we were never on opposing sides. All those years, none of my arrestees took a public defender's case where you were the public defender. So that was pretty cool. But let me tell you something. In my experience, my life experiences as a policeman, all those years, I never had an issue with a public defender. A couple of state's attorneys got into it with me, but I never had an issue with the public defender. I got to say, everybody in especially at Skokie, was very professional.
Oh, that's good to hear. Glad to hear that.
All right. So, before we talk about your book, and we will get to it, you got 34 years experience. I want to talk about some of your interesting cases. And before the show began, we were talking about, let's talk about a couple of DUIs, because that's right up my alley, because I'm a DUI expert. There was a case of a guy walking at a gas station. Why don't you tell our listeners about that one?
Oh, in that case, I was a young lady who was out today driving with her father. They may have gone to shopping, and she stopped to get some gasoline at the gas station. While she's at the gas station, a cruiser pulls up behind her, and the officer gets out, asks her name, and says, Miss, I ran your plate, and there's a warrant out for your arrest. And she was totally surprised. Her father was surprised, and she said, what's this about? And he says, I think it's a DUI warrant from about 3 years ago. And he has her name and know where she lives. So the officer was very kind. He didn't have to do this, but he said, if you promise to go to court tomorrow and straighten this out, I'm not going to take you into custody. So she says, oh, absolutely. So this was a Thursday afternoon. Friday, she goes to court to see what's going on. Why is there a warrant? And because her case was not on the call Friday, they're called like walk-ins. And if you're a walk-in, that means that your case is not on the call. They got to go to the clerk's office and get your file, so they hear these cases in the afternoon. So it's Friday afternoon. And they call her case fairly late. And she walks up to the bench, and the judge looks at the file and says that there were fees and fines assessed 3 years ago that were never paid. So he took that as kind of a personal affront, perhaps, and said, you will go with the sheriff's. And she doesn't know what that means, go with the sheriff's. Most people, what's going on? Well, the sheriff's come. They're going to take her into custody because of these outstanding fines and fees that were never paid 3 years ago. And so the judge gets off the bench. Now the woman finds herself in the custody of the sheriff's. They take her into the side room where there's a lockup, and they take her purse and they empty it upside down. Everything goes flying. Very indignant. And she's distraught. Well, a few things happened here that were improper. For the first thing, when the judge should have read the file, that was an error of omission, that he did not read the file. Because if he'd read the file, he would have seen that the woman paid $2,000 3 years ago in bond, and they never took the money out of the bond. The fines and fees added up to less than $1,000. She had $2,000 posted. They owed her over $1,000 for the past 3 years.
Because she had posted bond, correct?
She posted bond. It was right there. The clerk erred and never taken it out of the bond. And they're supposed to do that. They're supposed to take the fines and fees out of the bond, and they screwed up. They didn't do it, so it looked like she didn't pay. So the first judge made an error when he issued the warrant, because that was a mistake when he did that. And that was a different judge. And you know, you got to wonder where the state's attorney is. Are they in the courtroom? And the clerk also goofed up. So now she's in custody, and I asked to look at the file. I look at the file, and I see exactly that. $2,000 up that they never took the money out of, and they owed her $1,000. So how are we going to get her out of jail? It's now late on a Friday afternoon. Most of these judges are gone home. I got to find a judge. So I got to go looking for a judge in the building, and there in a lot of empty courtrooms. And then when you do find a judge, convincing him to overrule another judge's ruling is not something that they like to do. So luckily, I found the chief judge. God bless, may he rest in peace. That man, he came down. Once he learned the facts, he let her out of jail. Otherwise, she was going on a bus to the Cook County Jail. So that was interesting. If I wasn't there and I didn't take it upon myself to look at it, because I knew there was an injustice. The other thing that went wrong was even though he was going to take her into custody, this was not a no-bond situation. It was not a no-bail warrant. She had a right to have bail set, and that didn't happen. That was another error of commission by the judge. And the other error was once she was taken into custody, her Sixth Amendment right kicks in. She has a right to an attorney. So she didn't get that either.
Well, let's talk about that for a minute. Right to an attorney. When people don't come with a private attorney to court, but they want to get a public defender, now there's a procedure. They have to fill out documents explaining their income, correct?
Yes, they fill out a document. It's a form. It's called Affidavit of Assets and Liabilities. And they're bound by their word. They're swearing under oath as to their assets and liabilities. So if they have no income, that's not dispositive because they could have a lot of assets that they could sell. So the judge looks at it, and it's a subjective decision, but they're very some are conservative in their appointments, and some are more liberal. If the case is one that can be disposed of that day, they might lean more toward a public defender. But it depends on the judge and his outlook. It makes a difference.
Yes, everything is dependent on the man or woman of the bench, because if they're strickler, something's not going to go your way or the defendant's way. If they're very liberal, they might get the case done that day. But anything can happen in court. And I've even seen it where there's a plea agreement and the judge refuses to go along with it.
That's true.
I've seen it. I've seen it in court.
Right. And that's normal. It's permissible. It's proper. What I have an issue is if when the plea agreement involves the state's attorney dropping the case. Once the case, the judge is not a prosecutor. He doesn't bring the charges. If a state's attorney is not going to charge, he's going to drop a case that's already charged, the judge can't force him to prosecute the case.
I agree with that. I was talking about a plea agreement where there was going to be some kind of sentencing and stuff like that, and the judge didn't feel it was correct. And that's where it's what you call pleas that blow up.
Exactly. And so what happens in those cases is, the bad news gets relayed to the defendant. The defendant makes a decision what he's going to do. Is he going to go to trial? Is he going to take the plea as is? Or maybe get a continuance? And if you get a continuance, if there's no record, you get a different state's attorney, a different judge, you can try it all over again. Or you might try, they're going to resist you making a motion for a substitution of judge. Once you have this conference with the judge and it doesn't go your way, you don't retain, as a policy matter, the right to substitute judges. It's forum shopping, and they don't like that.
And that's a legal maneuver, substitution of a judge. But if I remember correctly from my days on the cop shop, you only got a limited amount of time to file that, correct?
Right. In the first 10 days, it's or the first court appearance, it's automatic. You don't have to allege any reason. You get it as a matter of right, a substitute.
All you have to do is all the attorney has to do is ask for it, correct?
Correct. And they have to grant it. It's an unqualified right within the first 10 days. After 10 days, you still can make a motion for a substitution of judge, but you have to allege reasons. Say, for instance, you found out that the judge is related to the defendant, to the prosecutor, you have to allege some type of prejudice. And then that's heard by a different judge. So, yeah, you can still do it, but
see,
you have to show prejudice. It's much harder to do.
People don't understand when an attorney asks for a substitution of a judge, that judge may say, okay, you can have a different judge, but the attorney does not get to pick the judge. It goes at random.
Right. It's Russian roulette.
What?
It's Russian roulette.
Russian roulette. Yeah, so you could, if you're a defense attorney, you could be going out of the frying pan and into the fire.
Yeah, you can.
Yeah. So anyways, I didn't mean to interrupt, but I want to let people know how public defenders are assigned. So that story with that lady with the bond, she ended up not going to jail because they took the money that was due out of the bond that she opposed, correct?
Right, and those facts had to be brought out in front of a judge so that he could make the right ruling.
All right, so there was another DUI that you were referring to. You want to talk about that other case?
Well, I had one DUI that the officer, it's a good thing they have these dash cams because the cams cut to the chase. And in this case, the dash cam showed the police officer following a vehicle at nighttime for a good length, well over a mile. And he pulls the vehicle over, and you see him get out of the car and approach the vehicle to the driver's side. And then you see him standing there, bending over, looking in, and then he comes back to the rear passenger side. Now, I was appointed to represent a young woman that was in the vehicle, and they took her out of the car, and she failed field sobriety test, and I think she blew over the limit. However, she tells me she wasn't driving the car. And this is borne out. I mean, if you look at the video, you can't see into the vehicle. So whoever was driving it hopped over the seat and into the back car seat, so that when the officer approached, there's no one in the front seat, and there's 5 people in the rear seat. And he asks him who's driving the car. So he couldn't. I mean, he impeached himself when he said later he saw the person climb over. Because there's no way he could see that, because we're looking at the same thing and you can't even see into the car. And why would he ask 5 passengers in the back seat who's driving if he saw it? Well, anyway, I guess they run the plate. It comes back to this lady's name, so they charge the driver of the vehicle, and she tells me she wasn't driving the car. So the case on those facts, it would seem that it would be decided on a credibility issue, on the credibility of whether or not the officer saw her hop over and get into the back seat. But I looked at the case and said, well, maybe we don't have to have it decided on credibility. We can file some motions to quash the arrest, as he had no reason to pull the vehicle over. He wrote 2 tickets. One was for an improper lane usage under 11709, and the other one was for speeding. Now, when you file these motions, what you're saying to the judge is he had no reason to pull the car over. There was no reason to pull the car over, and there was a case that said, and many cases regarding search and seizure and what's reasonable under the circumstances. He had no reason to pull the car over. So we have to attack and throw out both of these tickets. The one is the improper lane usage. So we got the video, and it shows her driving for a mile, and she doesn't violate any lane markers. She doesn't go off onto the shoulder, anything. The car, and it showed that the car was being driven by someone who was not under the influence. It would be an inference that they weren't under the influence because they had no traffic violations, and they had control of the vehicle. So we showed that to the judge. We filed the motion, and the judge granted the motion with respect to the improper lane usage because there was no evidence of that. Getting the other ticket, however, thrown out, however, was a lot harder because how do you throw out a speeding ticket? Disprove that there was no speeding. Well, again, we were fortunate that there was a video cam. Now, the video cam does not display speed readings and if it did, it would have the speed of the officer's cruiser, not of the car that he's following. But anyway, what we did was this: I got an investigator, and on the videotape, you can actually see the route. There's landmarks, known landmarks, a store you might know, a speed ticket, a certain kind of funny-looking tree. But anyway, so what we did is I got an investigator. We went down and we retraced the route in our car with a stopwatch, and we noted our speed. And we did this route 3 separate times. And each time we mimicked the route that was on the videotape, we recorded our times and the speed. And every single time we completed that route, completed that route faster than the driver who got cited. And we weren't even doing the speed limit. So we proved that she could not have been speeding. And the judge agreed and threw that case out. So the DUI got tossed.
You know, that's interesting about videotapes. There's dash cam videos on the dashboard of the squad car. Now there's body-worn cameras. Now they're required. As of January 1st, 2025, these police departments are required to have that under the Safety Act. The body-worn cameras that are supposed to record the events of the stop or the events of the call. And then there's in-house cameras when you take it to the police station, when you're in a cell, when you're being interrogated, or when you're submitted to a breathalyzer test. Now, those videos usually are only saved for 30 days. I've heard some police departments further down south in Will County only save them for 14 days. So it's crucial for the attorney, whether they're prosecutor or the defense attorney or the public defender, to subpoena the in-house videos immediately. The dash cams, usually they're safe for 30 days, and the body-worn cameras by state statutes are only safe for 90 days. So it's important to put the motion for discovery immediately for the videotapes as an attorney, whether you're prosecutor or defense. And that's something that sometimes falls through the cracks, because I had a judge one time tell me, you know, the defendant was telling me one story and the policeman's telling me another story, and then I saw something that didn't lie. And I said, what was that, Judge? He goes, the video. Everybody was lying in that case that he was listening to. And it may not even be a lie. It may be a distortion of perception. They may not be reviewing the video. They may be doing it from memory. And memory has faltered people. You're aware of that in many cases. They think they remember, but that's not how things occurred.
Yeah, that's right. Every time you enter into an agreement, you should have something in writing, especially if they continue the case, because they're not going to remember. And you could say, we had an agreement on this, and they don't remember it. But you're absolutely correct. You have to subpoena these things right away, and that's perhaps at the bond hearing, because if the case gets continued for 2 or 3 weeks and the lawyer shows up 3 weeks later for the first time, he's only got 1 week left to subpoena that tape. Now, a good thing with DUIs is a Supreme Court case came down that said, finally, these videotapes on DUIs are part of discovery. They never were part of discovery before you had to subpoena them. But now they're just like the police reports. So they have to preserve the DUI tapes because it's part of discovery. You shouldn't have to subpoena that, and they're not supposed to erase it either, because it's part of discovery. It would be a discovery violation if they erased it.
All right, and let's get to this other one that we were talking about. It was a DUI Xanax case. Do you remember
that one? Yeah, I do. This was a terrible case. The man, it was the worst case of driving I ever saw. They had a video, and it's no wonder he didn't kill himself and a bunch of other people. An absolute menace. They finally get him pulled over, and the man cannot even stand up without falling over. And they take him to the hospital, and he's got Xanax in his system. What had happened at this trial was that there are 6 separate sections of DUI, from alcohol per se level to being actual under the influence, drugs and alcohol combinations, other intoxicating substances, and also illegal substances. For instance, if you had cocaine or heroin in your system, they don't have to show you're under the influence of it. All they have to do is show it's in your system, and you lose. You're found guilty of DUI. Other substances, they have to show that you're actually under the influence of it. Sometimes they need an expert witness on that. If it's on drugs, they would need an expert they need an expert witness. But when they give the field sobriety test, they're different for drugs. So they usually have to have a special officer called a DRE, a drug recognition expert. And there weren't that many of them around. They had special training, and they get a special set of field sobriety tests. Well, in this case, the state made a couple of errors that cost them. They charged the defendant with A6, which is driving under the influence of illegal drugs. And now, all you have to do is get the lab.
Now, if I remember correctly, that statute under 11-501A6, that's any drugs in your system, in your blood or urine, correct?
Those drugs would...
And that comes from the toxicology report.
Right, and those drugs are listed under Chapter 56 and a half. They list these...
Correct.
Okay, so...
So that evidence is all from a toxicology report, and that's why they charge a ticket.
Now they mischarged. This was not Xanax is a prescription drug, so it's not an illegal drug per se. It can be illegal if you abuse the prescription, or if it's someone else's prescription, and it's not yours. Then it's an illegal drug and you fall under A6. But if you've got a prescription for it, it's not an illegal drug per se. They have to show that you're actually under the influence of it, and they would have to bring in an expert witness.
So they charged the wrong citation.
Wrong citation. Now they can charge wrong citations. They can charge multiple citations, and that could be as long as they get one right. That's all they need is one.
All right, we got about 30 seconds left. We're going to go to a break. We're going to finish this story when Bob gets back on our second half. We're going to talk about a couple of retail theft cases and a couple of warrant cases that he was the public defender on. Some really interesting conversation going on. If you have any questions, call us. Our phone lines are open. Stay with us. Life Experiences with William Pelarenos will be back in 3 minutes. Don't go away.
I'm Trey Westerberg on 1410 WRMN Elgin, proudly serving the Fox River Valley.
Brought to you by Sky Rizzy.
Pre-trial release was denied Monday for an Aurora man charged in an early Sunday morning shooting that injured 2 men near Fox Valley Mall. 24-year-old Aaron Conley of Tall Oaks Drive in Aurora turned himself into police on Monday morning and was charged with 2 counts of attempted first-degree murder, 2 counts of aggravated battery with a firearm, 1 count of unlawful possession of a firearm by a repeat felony offender, and 1 count of unlawful possession of a firearm by a felon with prior forcible felony. A car fire spread to a townhome in Naperville Tuesday morning, leaving 1 unit of the building uninhabitable. Firefighters got a call just after 12:45 a.m. reporting a car had caught fire in the 500 block of Scotts Drive. When they got to the scene, fire crews found a vehicle in flames that were extending to the nearby townhome. All residents had gotten out safely. The fire was contained by 1:11 a.m. It's estimated the total cost of damage is $110,000. A Batavia man accused of leading police on a drunken high-speed chase after fleeing a crash Monday will remain in jail pre-trial, according to the DuPage County State's Attorney's Office. A judge granted the state's motion to deny 28-year-old Michael Fox pre-trial release after he was charged with 2 counts of aggravated fleeing and eluding, 1 count of aggravated driving under the influence, and multiple misdemeanor and petty traffic offenses, including DUI, reckless driving, failure to reduce speed to avoid an accident, and transportation of open alcohol by a driver. Shortly after 5 p.m. Monday, the Warrenville Police Department received a call about a hit-and-run at Route 59 and Joliet Street. Fox fled and a chase ensued, the driver blowing through a red light at Route 59 and Butterfield Road and crashing into the front passenger side of a Honda CR-V. The SUV's 2 passengers were taken to a local hospital with minor injuries. I'm Trey Westerberg on 1410 WRMN Elgin, proudly serving the Fox River Valley.
Let's go! You're still glowing, flirting, grooving. You still got it. But your immune system weakens as you age, making it harder to fight flu, pneumococcal pneumonia, RSV, and COVID-19. Vaccines are a key part of any health routine and help strengthen your immune response. Ask your doctor or pharmacist which vaccines you need. Schedule in minutes at vaxassist.com. Sponsored by Pfizer.
If you didn't think skipping breakfast was a big deal, you'd be right. Before. But now, Wendy's has Buck Biscuits. We're talking sausage, egg, and cheese biscuit, bacon, egg, and cheese biscuit, or even the Honey Buddy Chicken Biscuit. For just $1 each. Seriously, you can get all 3 if you want. They're just $1, so you'll never skip breakfast again. If you're smart. Breakfast for $1? Gotta be Wendy's.
Limited time only. Price and participation may vary. Limit 5 qualifying items per transaction. Not valid in the combo while supplies last.
This is Sarah Silver with your Fox Valley forecast. This afternoon, mostly sunny with a high near 90. Tonight, a slight chance of showers and thunderstorms after 1 a.m., partly cloudy with a low around 72. Looking ahead to tomorrow, a slight chance of showers and thunderstorms, partly sunny with a high near 91. It feels like 101. Currently, it is 87 and mainly clear. I'm Sarah Silver on the Talk of the Town, WRMN.
If you need to hire, you know it takes time. Well, what if you could meet with qualified candidates the very next day? Now you can with Zip Intro from ZipRecruiter. You simply pick a time and it does all the work of finding and scheduling qualified candidates for you. Then you choose who you want to talk to and meet with great people on back-to-back video calls as soon as the next day.
Try Zip Intro for free at ZipRecruiter.com/free. Zip Intro. Post jobs today. Talk to qualified candidates tomorrow.
Twin Zeros at 4870 North Harlem Avenue in Harwood Heights, Illinois. Check out the full menu at twinzeros.com. Twin Zeros Restaurant in Harwood Heights not only serves traditional gyros, but also has chicken gyro sandwiches. Twin Zeros also serves a variety of sandwiches ranging from cheeseburgers and Vienna beef hot dogs that have recently been inducted into the Vienna Beef Hot Dog Hall of Fame. Italian beef, Italian sausage, and combo sandwiches. To ethnic favorites such as Slovakia and Grecian chicken. Slovakia is shish kebabs, specifically chicken or pork shish kebabs, grilled to perfection, served on a warm pita with tomatoes, onions, and our homemade tzatziki sauce. You can also enjoy barbecue ribs served every day. Twins is open 7 days a week and also delivers locally. Located at 4870 North Harlem Avenue in Harwood Heights. Check out the full menu at twinzeros.com. That's twinzeros.com.
The new novel, titled DUI Jury Trial, is the true story of two lawyers who defend a truck driver who is charged with DUI. If he's convicted, this truck driver faces a lifetime disqualification of his commercial driver's license, which would prevent him from ever driving a truck again. This 3-year legal battle culminates in a courtroom showdown, which involves the testimony of a DUI expert witness. This book, DUI Jury Trial, is now available on Amazon.com and BarnesandNoble.com.
Are you looking for a way to be creative right now? Have you ever wanted to learn to watercolor paint? You can now do that from the comfort of your own home with Zoom watercolor classes. Get professional instruction from nationally showing artist Victoria Elizabeth. These classes are step-by-step, broken down with easy-to-understand instructions. They are affordable, too, at $15 for a 2-hour class. Visit her website at victoriaelizabethart.com to find out more. That's victoriaelizabethart.com.
Welcome back to the second half of Life Experiences with William Pelarenos right here on WRMN 1410 AM, broadcasting out of lovely downtown Elgin. And we are here with Robert Mucci, who was a public defender for 34 years with the Cook County Public Defender's Office. He's telling us some stories of some cases that he handles as a public defender. And while we were at break, the phone lines are ringing. So let's get to the first caller real quick.
Hi, caller. Welcome to the show.
Hello?
We can hear you. What's the question, my friend?
Oh, it's not a question, really. It's just that Bob's son, Nick, and our daughter, Marit, are married, and we're listening from Sweden. So we just want to say hi.
Well, good to hear you. Nice to hear you, Tom. Thanks for listening.
Hi, Bob. Go.
It's one of your friends, Robert?
They're calling from Sweden. Yeah, it's my in-laws. My
Seriously?
Very nice. Yes.
I told you the internet made the world a lot smaller. We have a lady that calls from Australia.
Oh, she's passed away, actually.
Did she?
Yeah, she did.
She won't be calling us anymore. That's a shame. Anyways, you got any questions before we go to the next story?
He dropped.
Oh, he hung up. All right, Bob, you were telling before the break, you were telling about a DUI case where the defendant was charged with driving under the influence of Xanax. And why don't you finish that story? I know they issued the improper citation as you were talking. What's the rest of it?
Well, the state has a burden of proof here, and they have to do certain things. It's a lot of work. I mean, you got to have witnesses come in, and if it's officers on not their key date, they get time and a half and that. So recognizing this, the state says, well, Mr. the state says, well, I stipulate to the lab report so they don't have to bring these witnesses in and lay the foundation. And I said, yeah, I'll stipulate to the lab report if you stipulate that all the drugs he had were prescription drugs that he had a prescription for. Well, they agreed to that, and we put it in writing. The trial was very short. The judge found the man guilty and stated that it was the worst case of impairment she had ever seen. And this fellow was looking at a long time in jail because I think this was his 4th DUI. And so it was a finding of guilty, and then I came back with a motion for the judge to reconsider her finding and rule not guilty, and I put out the reasons why. And the reasons why is I showed her the stipulation, which was in the file, that they couldn't deny. And in the file, the state stipulated that they were prescription drugs for which he had a valid prescription for. Therefore, the correct charge would have been A4, and they would have had to bring in an expert witness. And then I commiserated with the judge, and I said, I know, Judge, this is a bad case, and then I said, but we have no choice. You have no choice. It's got to be a not guilty based on the charge. And the judge acquiesced and found the guy not guilty. I wasn't really proud of that, but I did my job. I did what I was supposed to do. What the profession expects of me and what society expects of me when you have a zealous representation of a client. So even though you might disagree with the outcome, it was correctly achieved.
Yes, you got to give them something is known as effective assistance of counsel. If you don't give them effective assistance of counsel, they can appeal that based on that you did not give them effective assistance of counsel, and they can complain on you to the to your supervisors or the RDC. So you have to do the job that you're assigned or that you're hired for. Real quickly, let's go to retail theft case. It was a big box store. You were telling me before the break.
Retail theft is a very common crime. It happens all the time. And so there's so many cases that they have a special retail theft court, and they might even have a special retail theft call that's everybody in there is only charged with retail theft. So the big box stores are constantly sending their representatives, the loss prevention control agents, to testify. And over the years, I've cross-examined these with same people over years of time, the same ones. One day I go into court and I see this one woman that I cross-examined as an adverse witness for a big box store. I see her sitting in the pew with the defendants. And it's kind of scary, what's going on here? Turns out she got arrested for retail theft. And next thing I know, the judge appointed me, and now I'm representing her. She's my client. So she tells me the story, and I deduced that this is a garbage case. But the state's attorney, I don't know how much time they looked at it, because they should have concurred. But no, they're going to prosecute her. So I think that this case is a slam dunk. We go to trial, and these are the facts. The woman's going to an event. She wants to buy a dress and look nice, so she goes to the store and buys 2 dresses, $20 each. And she leaves. Well, I guess she gets home and tries them on, and they don't fit. Something wrong with them. But she's got a receipt, and the receipt says exchanges within 3 days. So she goes back the very next day with these 2 dresses to return them. And she sees another dress she likes. This one's for $30. So she's going to return the 2 for $40 and buy the 1 for $30. She goes up to the counter, and they're not honoring it. They won't make the exchange. And she's arguing with us. She needs the dress. The event is tonight, and they won't make the exchange. So she makes her own exchange. She leaves the 2 dresses for $40 and takes the 1 for $30. And simple math, they owe her $10. But anyway, she leaves the dresses there, gets to the door, she's stopped, arrested, and here we are today. We find ourselves at trial.
Because she didn't physically pay for that certain dress, correct?
Right. And they owed her $40, and the dress was only $30. So we're in court. All these facts are brought out, and you'd think that'd be a slam dunk. But the judge raises his gavel, slowly hammers the desk, and says, "Finding of guilty." And I said, "What did you say?" And he said, "Finding of guilty." And then I said, "Judge, I must have done a terrible job." I go, "But then again, I'm not a civil attorney." I go, "This is a civil case. It's a contract case. This receipt is the contract. We've got the items, the price, the date, even the time, the amount that she paid. I said, if anything, they breached the contract, and they owe her $10. So the judge raises his gavel again, and now comes down and says, finding of not guilty. And this sent the state's attorneys skyrocketing, bouncing off the ceiling, because it's like taking a raw steak out of a dog's mouth. But it's rare that you get a judge to reverse himself like within 60 seconds. And that's what happened with this particular lady who I cross-examined as an adverse witness for years. And now I found out I was representing her. So I thought that was a little interesting.
You'll be surprised who ends up in court. Sometimes it's a personnel dispute. I remember one time where in the Skokie courthouse, two employees got into an argument. One may have touched the other one while she was walking away, and it was two ladies involved, and the one that got touched wanted to cite a battery complaint against her fellow employee. And then they had to move it out of Skokie because the judges knew all the players involved because they appear in front of them. And I don't want to say what what division it was, but they moved it to Bridgeview. And, things get complex. You never know who can fall into the legal system.
Hey, Bill,
even though you work for the legal system, you never know. And I want to say two things about retail theft. First of all, we've seen those horrible videos where people go into stores and steal tons and tons of merchandise and just walk out. That's horrible. But there's also cases where people, like your case, should not have been charged to begin with.
Yeah.
It could have been easily resolved by a refund or a store credit. There was one case, and it bothers me to this day. It was in the 90s. I got called to a certain clothing store. I won't name the name of it. And they had a person in the manager's office, and what it turned out to be, big Russian fella, big thick accent. I had a hard time understanding him, but once I deciphered, he's there with his family, his wife and two kids, shopping at the store. He's getting in an argument with his wife. Now, at the time, he wanted to buy a tie. He had the tie in his hand, a $13 tie. He had the tie in his hand. As they're walking in, she has items to check out. And he gets mad at her and doesn't want to talk to her no more. And he's caught in the emotional turmoil of the argument. And he walks past, they have these little electronic things that go do when you go off with an item. But there's two loss prevention people sitting right there. I mean, and the tie is in his hand. It's an obvious.
Right.
So they grab him, they detain him. So I told him, and he told me, I forgot the tie was in my hand. Now, I've had it where I can't find my keys, and my keys are on my belt, or sometimes I'm holding the item. So I know what it's like when you're emotionally distraught, to get absent-minded or confused. And I was much younger back then, and it's happened to me. So I told the manager, hey, obviously there was no intent to permanently deprive, and that's the statute of theft, the intent to permanently deprive. I go, he may have walked past these sensors, but the man had no intention of stealing. If he was, he would have hid it in his pocket. He wouldn't have done it with his family there in obvious sight. It's in your hand, and you're walking past the two loss prevention. I mean, what kind of a thief does that? So I said, hey, it was just a domestic dispute that escalated into this situation. So I told the manager, I'm going to write it up, and retail stores have this criminal trespass notice. If you don't conduct yourself in the manner that they think you should be conducting, or if you commit a crime, they don't want to prosecute. They have you sign this agreement that you will never come in their store again. If you do, you could be charged with criminal trespass. Are you familiar with these?
I've heard of them.
Yeah. So I told him, just have him sign that. And he was willing to do it. And he was willing to pay for the tie. It could all have been resolved. So I wrote the report. I drove away. I'm driving down the Gulf Road. I'm going to get some lunch. I get a call. Call the sergeant. So I get on the phone. The sergeant says, hey, the manager complained about you not arresting that Russian fellow. Go back and arrest him. And I told him, I don't think we're justified in doing this because I don't think there was an actual intent to permanently deprive.
Right, and when you take possession of merchandise which is past the last register, last point of purchase, it's not automatic guilty. There's a presumption that you can rebut, because all these stores have merchandise that's beyond the last point of purchase. They use every square foot of the store they can. They'll have things. They'll even have things stacked in the lobby. Lots of times you go into the stores and they have cans of soda pop in the foyer there. And if you take possession of that, you're past the last point of purchase. There's human beings, the human condition. I had one where the woman ran out of the store without paying for it, and that's because she had a little toddler that was 3 years old. And the toddler went through the door, and she went into mom mode because it was a busy street. So she ran after her child, and she didn't have time to, put things down in that. And so, yeah, you got to take this into consideration. They even have a retail theft school because of all the cases where they send you to theft school, and if you complete the classes, they drop the case.
Well, on that point, as policemen, we have some discretion. I was documenting the incident. I had everybody's name. The merchandise is going to be paid for. But this manager was adamant, and he went over my head to my supervisor, and I was ordered, and I wrote that in the case report, I was ordered by the sergeant to arrest this man. So I went back. I told him, do not say anything until you get your lawyer. All I want to hear from you is booking questions, your name, your date of birth, your address. That's it. I don't want to hear nothing about this case. You have the right to remain silent. Use it. Took them, processed them. First court date, guess what? The manager's not there to testify against this guy. So I told the state's attorney, you know what? Don't just take a continuance. I want you to subpoena that manager personally. They went to the retail store. They're investigators. They handed that man a subpoena. Made him come. He sat there for the entire court call. Towards the end, I told his defense attorney, hey, just put me on the stand. You're going to win this case today. I go, there's no slam dunks, but I got something to say in this case. I'm the arresting officer. You know what the defense attorney told me? Oh, the state made me a deal. They're going to drop it to disorderly conduct with a $100 fine. I go, you're selling out your client. I go, no. He says, I'm resolving the case. We're done. $100, 2 court appearances for a $13 tie. Welcome to the system. So anyways, with that being said, let's go. We're going to do another public defender's case that you were on. A warrant did a gas. Oh, you already talked about that one. How about this warrant with Larry Williams?
Yeah, you got a fairly common name. Larry Williams didn't come to court, so they issued a warrant for him. And they bring him into court. And now you got to have a good reason why you didn't show up to court. But some judges don't want to hear it. Others do. Anyway, they're going to hold him in custody to the next time that this particular police department is going to be scheduled in court. So they asked me, do I want a 7-day date with him locked up or a 14-day date? And I said, well, Judge, how about we just hold it over to the afternoon and get a booking photo, because I'm talking to Larry Williams here, and he says that you want Larry Williams Sr., and this was Larry Williams Jr. So they didn't bother to check the ages on the warrant. So, and they were all prepared to lock this guy up for 1 to 2 weeks.
So it was his father they were looking for.
Yeah, they was looking for his father.
You know, this reminds me of a story. I went to high school with a friend of mine. After high school, he was working as a taxi driver. He gets stopped for some traffic violation. They arrest him on a warrant. It's his name, it's his date of birth, the address, everything's correct, except it wasn't him that committed the crime. His younger brother used his identity at the time of arrest. And this is late 70s, early 80s. So, I mean, when people were arrested, the photos didn't pop up automatically like they do now. Everything's computerized. All they had was a name, date of birth, but they did fingerprint him. So even though he went to court and he says, hey, I am so-and-so, but I did not make this arrest. I was never arrested. The only time I was arrested was driving this cab on this warrant. That's not me. And I know who's using my name. It's my brother. And the judge made him get an attorney. Can you believe this? He goes, I had to hire an attorney to resolve this. So they get it resolved. They get the warrant quashed. It's taken out of his name. It's re-entered in his brother's name. Years pass by. That man who was the taxi driver who went through this whole nightmare actually becomes a policeman. And because he had been through the ringer in the system for something that wasn't his fault. He was one of the best policemen. Never, you hear about all these 5 complaints. Never had a complaint while he's 20 years on the job. He just came, did his job, walked away, and he always tried. He says, I always tried to help people sort out their mess. And that was a good policy. So as we're winding down, before I get to your book, because you wrote a very nice book, and I just ordered it off of Amazon, there was one more case that I wanted to talk about, a hit-and-run case real quickly.
I did a lot of hit-and-run cases. This one involved just it happened at nighttime, and there was a witness, and they say never ask a question you don't know the answer to. It's on cross-examination. And our witness was testifying about in mitigation and in the defense about the accident, and it was nighttime out. And of course, they got cross-examined. Were there any street lights? No, there were no street lights. And it was dark out. Yeah, it was dark out. And how far away were you? Oh, you were almost a block away. Okay, so how can you? You're almost a block away. There's no street lights. It's dark out. So how far can you see in the dark? It was the open-ended question. And the witness says, I don't know. How far is the moon?
He said that in the stand.
Yeah.
He can see the moon.
Yeah, so I gave it. The lawyer should not have asked that question, and he quickly paid for it. I had another case.
No, really. Okay. You know what? That's a good one, and that goes under cross-examinations.
Right.
There's a lot of things that can go your way or against you at cross-examination. I want to get to your book here, and as we're showing in here on YouTube, you're going to have to pronounce the title because it's a tongue twister for me.
It is. I was looking for something unusual, and I think I succeeded with that title. It's called The Vaster-Bottensost Affair. Vasterbottensost.
And the author, if you can't put that in, just when you're Googling on Amazon or on the publisher Ex Libris, put Robert Mucci, Mucci, and it'll pop right up. But Tell us, this is a fictional novel about some espionage. Go ahead, tell us.
Yes. It's about a family, father, 2 sons, and daughter, mom. American family where the father served in the armed forces, and his 2 sons grew up in his footsteps and entered the armed services. And it talks about their exploits in the services. And one of the sons was killed in active duty. The other son is near retirement, but he's on a special ops mission. It's a top secret mission, and the mission goes bad. People end up getting captured. They get tortured for information about the special item that they were entrusted to bring back to the United States. They can't find the item, and they can't find our guys. But finally, they find our guys, but they still can't find the item. There's a rescue involved, and then our guys are, once they're brought back, they're not treated very nicely. They're treated as suspects in the disappearance of this item. I wrote the book trying to develop characters that the audience could identify with, put themselves in their shoes, their feelings, how they interact with each other, and how they solve problems that many of us face on a daily basis. The book takes place in Sweden, the North Sea, and Washington, D.C. The name Vasterbottensost is actually a name of a Swedish cheese. And the first I heard of it is my son's living in Sweden, and they were making this cheese in one little town, and they let it cook too long. The woman fell asleep and thought she ruined it, but they ended up liking it so much they decided to continue making it that way, and it became the official cheese of the King and Queen of Sweden. So you can buy it now, and it's got the royal seal on it. And the cheese also plays an important role on the location of the secret item that everybody's looking for. I visited Sweden.
Before you get to that,
okay,
say the name of the book one more time.
It's called the Vasterbottensost. 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 When I was writing the book, a couple of times I had to get up off my chair, go into the kitchen, into the fridge, and get the cheese out because I couldn't remember how to spell it. And I wanted to spell it right in the book.
All right, that's a great title. We're down to a minute, Bob. So this is on xlibris.com, which is the publisher, as well as Amazon.com.
Yeah, it's easy to find on Xlibris. Just go to xlibris.com, click on the bookstore, and then enter the Vasterbot and Zost affair, and you'll find it very easily that way.
Okay, follow me on Facebook at Pelarenos Police Project. And follow me on Twitter at Police Project 1. We'll be here next week with another guest. I thank Bob for taking this afternoon off and coming and telling us all these criminal case stories that he experienced. And we got a lot more. There was 3-4 more that we had discussed that we didn't even get to. You'll have to come back in a future date and talk about these.
Thank you.
I appreciate it. But thank you very much, Bob. And catch us next week right here on Life Experiences with William Pelarenos on WRMN 1410 AM. Have a great week.